Hillchos Mlova Velva, chapter 22:1. This is the order of which debts are collected when the creditor brings his promissory note to the court and the authenticity of the witness's signature are verified. We tell the borrower will pay. We do not attach this property until the creditor demands this. If a judge errs and gives the creditor access to the borrower's property before it demands it, remove the creditor from it. If the borrower responds, I will pay. Establish a date for me so that I will have time to borrow money from another person, offer my land as collateral, sell property, or bring the money. We grant him 30 days. We do not require that he bring security to the court, for if he possesses movable property, the court will expropriate it immediately. If the creditor desires, he may have a conditional ban of ostracism issued against anyone who possesses money or movable property and uses arguments to avoid payment. We do not require the borrower to bring a guarantor until he pays. The borrower is not brought payment within these 30 days. When these 30 days are concluded, the court composes an adrachta. Similarly, if at the outset, when the lender demanded payment of him, he said, I will not pay, we compose an adrachta against his property immediately and do not grant him any time. Similarly, if what is involved is a loan supported by a verbal commitment to loan, and the borrower admits his obligation, we compose an adrachta against the property and that is presently in his possession. 2. The following was applied when the borrower claims the promissory note concerning which the signatures of the witnesses was validated as a forgery. I will bring proof and nullify the matter. The witnesses are located in this place, and their names are so and so and so and so. It appears to the judge that there is substance to his words. The time is established in which he must bring his witness to court. If it appears to them that he is merely raising deceptive arguments and fallacious claims, they should tell him pay. Afterwards, if he brings proof of his claim, the money should be returned to him. If the creditor is a man of force and it is impossible, and that it is possible the money will not be recovered from him, it should be entrusted to a third party. 3. When the time was established for the borrower to prove and nullify the promissory note, that time came and he did not come to court. We wait for 3 months. Wait for 3 court sessions, Monday, Thursday, and Monday. If he does not come, we compose a peticha against him and place him under a ban of ostracism. We give him a further respite of 90 days while it's under the ban of ostracism. The first 30 days for perhaps he's seeking loan. The middle 30 for perhaps he's seeking to sell property. The final 30 perhaps the person who purchases property is seeking to bring him the money. When these 30 days are completed and the borrower still does not appear in court, the court composes an adrachta against his property and releases him from the ban of ostracism. 4. The borrower lives within a 2-day journey or less from the court. We do not oppose an adrachta until we send messengers and inform him of this impending step. If he lives further away, it is not necessary to inform him. When does the apply? Well, throughout the entire 90 days, he would procrastinate and say, just now I'll bring proof that nullifies the promissory note. However, he says, I refuse to appear in court. We compose an adrachta against both movable and landed property immediately. Similarly, if a person is being sued on the basis of a legal document recording an object entrusted to him for safekeeping, we do not wait until 9 days. Instead, we compose an adrachta against his property immediately. 5. The statements are made above. If the borrower does not come at the conclusion of the 9-day period, we compose an adrachta with regard to landed property. With regard to movable property, by contrast, different rules apply. When after 9 days, as long as the borrower says, I'll bring proof and nullify the promissory note, we do not allow the lender to expropriate movable property. The rationale is that the alleged lender might consume it afterward. The borrower will bring proof that nullifies the promissory note and will not find property belonging to the alleged lender that it can be collected for repayment. This applies even if the lender possesses landed property, for perhaps that property will decrease in value or become dried out. 6. How is the adrachta composed? If we are expropriating property that is in the borrower's possession, we write in the document, so-and-so is obligated by judgment to pay so-and-so this amount. He has not made this payment on his own volition. Hence, we have composed this adrachta against this and this field that he possesses. Afterwards, the 3 experts divide a portion of that field equivalent to the value to the debt that he owes, and its prospective sale is announced according to the appraisal until those who add to the estimation make their bids. If there are no buyers, we transfer ownership of that portion of the field to the creditor because of his debt and rip up that promissory note if such a document exists. If there was no other property in the borrower's possession, we compose the document which states so-and-so undertook an obligation to so-and-so as recorded in the promissory note possessed by the creditor. The debtor has not paid his debt. We have not found property that is presently in the debtor's possession. We have already torn up the promissory note that the creditor possessed and given him license to seek out and research whether there are any properties that are sold from this date onward with the intent that his hand be raised over them. He has license to derive payment and expropriate his debts from all such properties. 7. After this document is composed, the lender goes and seeks property belonging or that once belonged to the borrower. If he finds property that is in his possession, they are valid for him. If he finds only property that has been sold after the date of the promissory note, he may expropriate it. We tear up the adrachta and write 8 tirpa. 8. How is a tirpa composed? We write because of the debt of this and this amount that so and so the borrower owes him. So and so the lender won in court the right to expropriate this and this field. So-and-so purchased for this and this amount and this time. We have already taught the adrachta that was in his possession. We have given him license to expropriate this amount from this property. 9. After the tirpa is written so that the lender may expropriate the property, we bring 3 experts to that field to evaluate the field and price how much of the field should be given to him for the principal half of the field's increase and value was explained. We then announce the property sale within 30 days in the same manner as we announced the sale of property inherited of orphans. 10. Afterwards, the borrower is with us in the country. We require the borrower to take an oath that he is bankrupt or as named by our sages. We also require the person to expropriate the property to take an oath while holding a sacred object that did not collect payment for this debt and did not waive payment of it and that he did not sell to another person. Afterwards, we give the land in possession of the purchaser according to the assessment of the debt owed him, and we compose a hayrada. 11. How is this document composed? That is right after we had an evaluation of property made for so-and-so because of the debt he was owed. We announced the sale of property as in fitting, as is fitting. We require both the person expropriating the property and the debtor to take the appropriate oath. We have given so and so possession of this in this field. He may use it as a person uses property that is acquired. 12. From which time the person who seeks to expropriate this property to our benefit from this. From the time the days of the announcement are completed. 13. Whenever an adactyl does not state we have torn up the promised note, it's not acceptable adactyl. Whenever a tirpit does not state we have torn up the adactyl, it's not acceptable tirpit. Whenever a shuma does not state we have torn up the tirpit, it is not acceptable shuma. 14. When 3 experts then to evaluate a property, one evaluates it worth a mana, 2 evaluates worth 200, and one evaluates worth 200, and the other 2 evaluates worth a mana. The assessors who offer the loan opinion is considered insignificant. If one assessor evaluates it worth a mana, another 80, then a third 120 is considered to be worth 100. If one says 100, the second 90, and the third 130, it is considered 110. That is our pattern of evaluation. 15. When the court evaluate a property belonging to a purchaser on behalf of the person who sought to expropriate an error, even if the error was concerning the smallest amount, the sale is nullified. The rationale is, since the court is considered to be an agent, the person expropriating the property and the purchaser, they have permission to expedite the matter, but not to impair anyone's position as the law applying to an agent. All the authorities ruled in that manner. 16. When the court evaluates an expropriated property for a creditor, whether from property in the creditor's position or property that was in the possession of a purchaser, and afterward the borrower, the person from whom the property was expropriated, or the heirs acquires financial resources and pays the creditor with money, the creditor is removed from that landed property. For the property that was evaluated and expropriated shall be returned to its owners as mandated in Deuteronomy. You should do what is just and good. 17. When the court evaluates and expropriates a property for a creditor, and then evaluates and expropriates a property for the creditor of that creditor, the original creditor can redeem the legal power of the second creditor is no greater than that of the first one. The creditor sold the property expropriated from him and gave it away as present, gave it to his creditor voluntarily, who died, and the property was inherited. The original owner does not have the right to redeem it. If the landed property was evaluated and expropriated for a woman, and then she married, or property she owned was evaluated and expropriated from her, and she married, her husband is considered to be a purchaser with regard to her property. He is not required to return it, nor must he return it to him. Mloa Veleva, chapter 23. 1. Promissory notes that are predated are invalid because they will be used to expropriate property from purchasers in an unlawful manner. Accordingly, our sages penalized lender, ruling that he may expropriate only property in the debtor's possession with a predated promissory note. This is a decree enacted lest he expropriate property from the first earlier date. 2. Post-dated promissory notes are acceptable for the legal power of the possessor of the promissory note has been diminished. For the lender can expropriate only property from the date of the promissory note, from the promissory note. Even if the document does not state that it was post-dated, it is acceptable. 3. When a promissory note is written during the day, it is signed during the night that follows it. It is unacceptable because it is predated. If whoever the borrower and the lender were involved in negotiating the matter until night fell and they were signed, it is acceptable even when the kinyan was made at night 4. When the promissory note is dated on the Shabbos or on the 10th of Tishri, we assume that it was post-dated and that it was acceptable. We do not suspect that perhaps it was predated and was written on Sunday or the 11th of Tishri. Instead, we accept the presumption that the promissory note is acceptable. The rationale that it is known legal documents are not composed on the Shabbos, therefore it was post-dated. 5. We may compose a promissory note for a borrower even though he is not accompanied by a lender. We do not, however, compose a promissory note for the lender unless he is accompanied by the borrower. When is he applied with regard to a promissory note that was affirmed by a kinyan from the time the kinyan was carried out, the borrower's property was on lien. When, however, the promissory note was not affirmed by a kinyan, we do not compose a legal note even for the borrower unless he is accompanied by the lender and gives a note to the lender in our presence. The rationale is that we suspect that a borrower may have document composed at this time, so they can take a loan on Nisan, but in fact the loan will not be given until Tishri. The lender will be able to use the promissory note to expropriate property that was in the borrower's possession unlawfully from Nisan, and the promissory note did not enter into his possession until Tishri. 6. The following is and witnesses perform the kinyan with the borrower, the seller, or another person involved in a business agreement, but the composition of the legal document was delayed extensively. If they remember the date in which the kinyan was established, they should write the date of the kinyan, the legal document, even though it was not the date in which they signed the legal document. It is not necessary for them to state in the document that our signatures were delayed until this in this date. If the witnesses do not know the date in which the kinyan was performed, they should date the legal document for the date which was composed. Similarly, if witnesses who observed a business transaction in one country compose a legal document in another country should not record the place where they observed the testimony of the legal document. Instead, they should record the place where they signed the legal document. 7. When deeds of sale are not dated with the dates of the transaction, even those that are post-dated are not acceptable. The rationale, the purchaser may use them to expropriate money in an unlawful manner was applied. For example, the seller could have repurchased the field from the purchaser before the date of the post-dated deed of sale. The purchaser could then produce the post-dated deed of sale and say, I return the purchase from you from a second time. Either could thus expropriate property from purchaser unlawfully. Why don't we harbor him suspicion with regard to the post-dated promissory note? It is possible the borrower paid the lender before the state and stated in the promissory note. The lender will write him a receipt and then produce the promissory note and expropriate property unlawfully. We do not harbor suspicion because whenever a person composes a post-dated promissory note, he can protect himself by having the receipt composed without a date. Thus, whenever the lender will produce the promissory note, the borrower can nullify or produce the receipt. If the borrower did not do this, allow the receipt to be composed dated in the day when the debt was repaid, he caused himself a loss. 8. When a person was compelled to sell his field against his will and issued a protest, or how he sold the field or gave it away to another person before he sold it to the person who compelled him to sell the money, and the person who compelled him to sell gave him is considered to be a loan supported by a verbal commitment to loan. He may not use the deed of sale to expropriate any property that has been sold by the sellers to others. This law is stated because the deed should not have been written, and it was only written under compulsion. So, split on analogous situation 9. Is it possible for a person to expropriate property without a legal document merely on the basis of verbal testimony was implied? If a person as witnesses will testify that property was stolen from his father, being expropriated property on the basis of this testimony, although there is no legal document. Similarly, if witnesses testify that a husband was concluded for his father to expropriate money from so and so for this and this amount, this and this time, and his father died without expropriated the property, he some may expropriate property on the basis of this testimony. 10. Therefore, we should never impose 2 deeds of sale for the same product, let the purchaser perpetrate the deception of the creditor expropriate property unlawfully. What is implied? A person will expropriate. This person will expropriate this field from the purchaser based on the testimony that his father had the right to expropriate. The purchaser will then use 1 deed of sale that he possesses to expropriate property from people who purchased property after he did when the borrower sold him the property. The court will then tear up the deed of sale that the initial purchaser possesses for the sake of deception. The person who expropriated the field will allow the purchaser to take possession of it again. He will then expropriate it again on the basis of the testimony of his witnesses. The purchaser will then produce the second deed of sale and expropriate property from the other purchasers unlawfully. If so, what the person has lost his deed of sale to a property due if witnesses are still alive. Second, the sale should compose, saying this deed of sale may not be used to expropriate property that has been sold or property that is in the possession of the seller. They compose only to establish so and so the purchaser is the owner of the field, so the seller or his heirs cannot expropriate from him. 11. This principle is not applied with regard to a promissory note, even though the witnesses are the loaner alive and enter into a agreement with the borrower. The lender returns immediately and tells the witness the promissory note that you composed for me is now lost or was burned. They should not compose a second promise note for him we suspected that was paid or that a way of payment the above applies, even if the loan was given for a period of time. The lender cannot collect any money on the basis of the testimony of these witnesses unless the borrower states the loan was never given. In that instance, he is established as a liar through their testimony, as will be explained. 12. When a promise note was in a person's possession was worn and is beginning to become effaced, the lender should have witnesses look at it. He should then come to the court, and the court will validate it. If the witnesses who signed the promise note itself, whoever may not compose another promise note on their own initiative, even when the promise note was blotted out in their presence instead, they should go to the court. The court will validate the promise note. 13. How should the promise note be valid? The court composes a document that states we, the court, composed of so-and-so, so-and-so, and so-and-so, saw how so-and-so, the son of so-and-so, produced a promise note that was effaced in our presence. It was dated on this and this date. So-and-so and so-and-so are his witnesses. The composed document required and the testimony of witnesses. The testimony was corroborated. The lender may collect the debt with the document that was composed for him. No further validation is required. If the court did not compose the document, the debtor protests the document. So forgery, the lender must also be proof regarding the signature of the written witnesses that the testimony will be validated. 14. When the promise note is torn, is acceptable if its wording is in the process of being rubbed out or muddled, as long as the form of the original notes are recognizable. It's acceptable if it was torn as the court hears a legal document. Is unacceptable in which manner does the court hear a legal document, both horizontally and vertically. 15. Following the parliament, person repays a portion of a debt recorded in a promise note. If the lender desires to exchange the original promise note, the court composes a new document for the remainder of the debt with lien beginning in the original date. The witnesses of the original promise note may not take this initiative. If he desires, he may write the borrower a receipt. 16. When a person comes to pay his debt and the lender tells him, I lost my promise note, the lender should compose the receipt for him, and then the borrower should repay the entire debt. The borrower may, however, have a ban of ostracism issued against anyone who hides his promise note and claims that it is lost. If the borrower lodges a definite claim saying this promise note is in his possession, he just placed it in his pocket. My masters have ruled the lender should take Ishwas Hasis that the promise note was lost. Afterwards, the borrower should pay the debt and receipt should be composed. 17. When a lender produces a promise note for a mana and asks that 2 promise notes for 50 should be composed do not comply, the rationale is that it is of benefit for the borrower to have the entire debt recorded in a single promise note. For if he pays him a portion of the debt, the legal power of the promise note will be repaired. Conversely, if the lender produced 2 promise notes, each one 50 cents, and asked that 1 promise note for 100 be composed, we do not comply. Instead, we validate them both individually. The rationale that it is the benefit of the borrower to have 2 promise notes so that the lender cannot compel him to pay the entire sum at one time. 18. When the lender produces a promise note for 100 and says tear it up and compose another promise note for 50, we do not heed his request. We fear that perhaps the borrower would pay the entire amount and the lender wrote a receipt for him. The lender authenticated in a promise note for 50 cents and the borrower produced the receipt. She told the borrower this is another promissory note. Hillchos Mloa chapter 24. 1. We have already explained that a promise note concerning a loan that was affirmed by a kingdom may be composed for a borrower even when the lender is not together with him. Similarly, we compose a deed of sale for a seller even though the purchaser is not together with him. When we compose a receipt for a lender even though the borrower is not together with him, we compose a receipt for the woman even though her husband is not together with her, for a bill of divorce, and a bill of divorce for a man even though his wife is not with him. We do not compose legal documents for consecration, marriage, and sharecropping agreements, business contracts, the choice of judges, the claims of the litigants, or any act of court without the consent of both principals. It is necessary to be careful about all the particulars of the composition of these documents as the case with regard to other legal documents. 2. Who must pay the scribe's fee for the composition of these documents? With regard to promissory notes, the borrower must pay. With regard to deeds of sale, the purchaser must pay. The woman must pay the fee for the bill of divorce. The groom must pay the fee for the documents of consecration and marriage. The receipt should be into the field. The sharecropper or the worker must pay the fee for the composition of a contract. With regard to the document recording the choice of judges and claims of the litigants, both parties must share the fee. 3. The following law applies. Both the legal documents composed for one of the parties when the other is not present, and legal documents that can be composed only when both consent and both are present, e.g. a promissory note written at the request of the lender, or a deed of sale written at the behest of the purchaser. In all instances, the witnesses must recognize the identity of the individuals mentioned in the legal document. This is so-and-so, the son of so-and-so, and this is so-and-so, the son of so-and-so. This is necessary lest two individuals come and try to perpetrate deceit, changing their names to the names of other people, and then acknowledge obligations to each other. 4. Whenever a person has established a name for 30 days in a city, we do not suspect that he has another name and has changed his name to perpetuate deceit. For if we would raise such suspicions, there would be no end to the matter. Therefore, if a person who has not established his name in a city for 30 days comes and asks, "Write a promise note for me that I am obligated so and so to this person for these and these many dinar," we do not compose the document for him unless he brings proof that this is his name, or wait until his identity, he waits until his identity is established. 5. The following laws apply when there is a dispute with regard to any promise or note produced before us. For example, the borrower claims not owe anything. Maybe a charlatan pretended that his name was mine and acknowledged owing money to this person, or he might claim, "I do not owe anything to this person, but rather to another person." This plaintiff is a charlatan in claiming that his name is the same as the name of the person to whom I owe. Since it has not been established that there are two people in the city with the same name, we pay no attention to his claim, for it is an accepted presumption that witnesses will not sign a legal document unless they know the identity of the people mentioned within it. Similarly, it is accepted presumption that witnesses will not sign a legal document unless they know with certainty that the persons making the statements concerning themselves are adults and mentally competent. And witnesses will not sign a legal document unless they know how to read and sign their names. When witnesses who do not know how to sign their names and the names of the witnesses were cut out from a blank paper and placed over a legal document, and then the witnesses signed with its script, they are given swept for by his conduct, and the promise note is unacceptable. 7. When the head of the court of law knows about the general circumstances described in the legal document, he may sign it even though he does not read it himself, but instead it was read to him by one of the scribes. The rationale is that since the head of the court trusts the scribe, and the scribe is afraid to lose his reputation. No other person can do this. A witness may not sign a legal document unless he reads it word for word. 8. The following laws apply when there are two people in the city, each named Yosef, the son of Shimon. Neither of them can demand payment from the other on the basis of a promise note that he produces, nor can a third party demand payment from either of them on the basis of a promise note that he produces, unless the witnesses who sign the promise note come themselves and testify. This is the promise note concerning which we testified, and this is the person concerning whom we testified regarding the loan. Similarly, such individuals cannot divorce their wives unless they do so in the presence of the other individuals. With the other individual with the same name. Similarly, if a person finds a receipt among his legal documents saying the promise note concerning the debt owed by Teiveis, the son of Shimon, has been paid, debts recording and the promise notes that this person owes to both of these individuals with the same name are considered to be paid. What should people with names and the names of their parents alike do to enable them to compose valid legal documents? They should write the third generation as identification in the legal document. The names of the grandparents are the same, they should write a sign. If the signs also look alike, they should write their family lineage. If both parents are priests and Levites, they should write further generations. 9. The following will apply when a person produces a promise note against the colleague that states, "I, so-and-so, the son of so-and-so, borrowed money from you." Although the name of the lender was not mentioned in the promise note, a person who produces this promise note from possession can expropriate payment with it. The borrower cannot rebuff the plaintiff by saying the promise note belonged to another person from whom it fell. Similarly, when there are two people named Yosef and Shimon dwelling in the same city, and one of them produces a promise note against one of the inhabitants of the city, the defendant cannot rebuff him by saying, "I'm obligated to so-and-so, the son of so-and-so, whose name is the same as yours," and this promise note fell from him. Instead, the person who produced the promise note may use to collect debt. We do not suspect the promise note fell. 10. The following laws apply when two persons produce promissory notes against each other. The latter cannot tell the first, "If I owed you money, why would you borrow from me?" Instead, each one is entitled to collect debt mentioned in his promissory notes. Both promissory notes were for hundreds. Both principals possess property of equal value, be it a property of superior quality, property of intermediate quality, or property of inferior quality. We do not attend to them. Instead, each person remains with what he possesses. If one possesses property of superior quality and property of intermediate quality, the other possesses the other only property of inferior quality, one should expropriate the property of intermediate quality and the other should expropriate the property of inferior quality. 11. The following is applied when a person produces a promise note against a colleague and that person produces the deed of sale stating that the alleged lenders of the field, if they are placed where the purchaser pays the money and afterwards the seller writes the deed of sale, the promise note is invalidated. The rationale is that the borrower will tell the alleged lender, "I was indebted to you, you should have used the money to pay the debt." In a place where the deed of sale is composed and then the money is paid, however the promise note is viable, the alleged lender can claim, "I sold you the fields that you would have known property from which I could collect my debt if you claimed bankruptcy."